Well, we knew that this was coming, and regardless of where you fall on this whole concept, um, whether it's it's about time or has society gone to seed, and it fell to the ground, and up sprung a large marijuana plant. And we at the state and national level must now wrap our heads around that, and as regulators, decide what is to be done. Because whether or not it's coming to a theater near us, right? If it has not already arrived. You may know that the panel is all composed of people from the left coast. They are the folks who have been dealing with this the longest and can bring the most experiential information to the room. But this is much more of a kind of a roundtable discussion in a square room, if you would, so that we can prepare ourselves as regulators for what has arrived and what is to come. At this time, we'll get you all Slidoed up. You all have the Slido app. If not, ask your neighbor. I'll let you do that while we worry about these people who are finding their identity still. Are we good? Well, let's go into the first question then. Regards to physical therapy, how familiar are you with the regulation of cannabis in the entire United States? Go ahead and plug in. And that's about what we had figured as they're coming in. See, this is such a new topic, but one thing I really love about coming to these FSBPT meetings is that they're very forward-thinking people. They see things on the horizon and they're very proactive in their approach. And so that when things do and can and do come up, we're as prepared as we can be. And that means not just the board of directors, but all of us as regulators. All right, here we go. What is the legalized status of cannabis use in your state? So as it's coming in, it sure seems like mostly medical marijuana folks or states. All right? Okay, interesting. And that will be, as this thing changes, so will the regulations in state to state throughout this country. Okay, I'm going to turn it over to Erica, but I just want to introduce myself. I am Katie Dale, and Erica Shanahan from Oregon, Jeffrey Kaiser from California, and my colleague on the Washington board, Jeff Foucrier. We also have Allison MacGyver in the room, who, interestingly enough, she's our program manager and came to us from the marijuana board. Yes, we do have a marijuana board, and you will too. So, anyway, without further ado, I'm going to hand this over to Erica, because you've heard enough from me for the time being, and she's going to give you kind of a contextual backdrop to kind of begin our discussion. Okay? So, let me get you started, Erica. Whoops.
Okay. All right, thank you. I was going to start with just some terminology. So cannabis is the plant. Marijuana is a cannabis plant with greater than 0.3%.
I broke the computer. I am the grandma.
That's a good thing. That's a good thing.
Where's my fax machine when I need it? Smoke signals will do at this point. Oh my goodness, we're at a cannabis thing.
You know all the jokes.
Is it working?
Not yet. I don't think we did it.
Oh, I think I did. If it can be broken technologically, I'm your gal.
display. I always come down here and push this.
Sure.
All right, cool.
All right, back on. Okay, cannabis is the plant. Marijuana, cannabis plant that is greater than 0.3% THC. Hemp is cannabis plant with less than 0.3% THC. CHABA stands for Cannabis Health and Beauty Aids. THC is the psychoactive component of cannabis plant, and CBD is the non-psychoactive component of the cannabis plant. Here's some more terms. Criminalization means it's illegal to possess, use, sell, or produce. Legalization is to make legal. It can be with parameters. Decriminalization removes criminal penalty but may still have a civil penalty. Expungement or pardon means the criminal offenses are removed or sealed. This is the timeline on the West Coast for legalization of marijuana. Oregon was the first state to decriminalize marijuana in 1973, and it wasn't until 1996 that Washington became the first state to decriminalize marijuana. 1996 when California legalized medical use. In 2012, Washington and Colorado became the first states to legalize recreational use, followed by Oregon in 2014 and California in 2016. These are the four main approaches by jurisdictions: full criminalization, legalization of medical marijuana, recreational decriminalization, and recreational legalization. This next slide includes a little bit more updated statistics, so the numbers are slightly different. 38 states and DC have legalized medical use, and 23 states and DC have legalized recreational use. This map gives a nice visual of where each state is in legalization. Dark blue means recreational use is legalized. Green means medical use is legalized and recreational use is decriminalized. Light blue is states where just recreational use is decriminalized. Yellow means medical use is legalized. Orange is states where CBD and TCH only is legalized. And then red is marijuana is fully illegal.
So to Katie's point, this is meant to be kind of a loose interpretation and a way for us to engage in conversation. The disclaimer is because everybody knows this is my favorite topic, right? I'm in my third career, and my second career in the 90s was in law enforcement, specifically narcotics, and I did a couple seasons, if you will, in the campaign against marijuana planting. So I oftentimes have to find myself kind of checking my biases and making sure that I'm open-minded in looking at these things as an administrator of a healthcare program in the state of California, where we have both legalized medical and recreational marijuana. Having said that, though, anytime that you have undiscovered territory, you have exploration. And in that exploration, there are some key sets that I think you need to keep in mind, and those are just your core values, right? And so when we talk about the first topic, which is licensee use, you want to take it down to at least its lowest common denominator, right? While we might not be sure about empirical testing for marijuana, it's not the same as alcohol, it's not as static, it's not as reliable. There's a lot of interpretation. Some of these things involve determining whether or not someone is impaired, and that's kind of the key word that you should be focusing on, is if you're talking about licensees and their use, whether they do it during the week or on a weekend or on a regular daily basis, are they impaired while they're in the workplace? You have the same concerns if they're impaired in the workplace under any other kind of mind-controlling substance, right? Whether it be pain medications or alcohol or anything like that. So into thoughts about disciplinary investigations, that's the key set, right? It's less about the fact that it's marijuana, and it's more about the fact that it's a mind-altering substance, right? and you are treating it in some states differently than others. California, it makes it very easy for us because while it's recreational and it's medical, we can treat the recreational side the same way we treat alcohol, right? We don't have the simplicity of a BAC, but we have the rest of the intent and the spirit of the statute to say, if you show up to work under the influence of a mind-altering substance, that's an issue that we're concerned about for our consumers in the state of California. Another, to Katie's point, while you might not have a cannabis board yet, you will, and like us, we did, and we now have a department of cannabis. So it can change. The other side of that is, in those kind of cases that you might have that involve substance abuse, marijuana falling into that category still, if you're testing for opiates, if you're testing for stimulants, if you're testing for alcohol, you can still test for cannabis in those disciplinary situations. California is kind of convoluted, right? We have a doctor's recommendation, and is a doctor's recommendation technically medically necessary, right? Is it an alternative medicine? Is it a medicine at all? For the purposes in California, at least, when we have somebody that has a substance abuse issue and we ask them to abstain from substances and alcohol, we ask them to abstain from marijuana as well, right, regardless. Panels involving metabolites when it comes to THC and the other 144 different identified cannabinoids at this point, and it seems like there's a different cannabinoid identified every day, if you kind of keep up on that, are an indicator in something that you should be you're concerned about for your consumers when it comes to impairment. And so for topic one, I'd like to open the floor to questions and comments. Everybody's scared. Relax, it's natural, it's from the earth.
Hi, Joe, New Hampshire. I like how you're crafting it with the intent of use, like how, no matter what the substance, is it affecting their ability to perform their job correctly? And I think if you use that, it really, because New Hampshire, we're decriminalized, it's legal for medical, but Maine, every bordering state is legal for recreational. So there's a lot of issues. But I think if using it that way, under the intent, with the impaired to provide services, it makes board's decision a heck of a lot easier. But I like that statement, Jason.
I think a lot of us in the room have been faced with cases that kind of fit into circumstances such as one of your licensees was reported to be intoxicated while at work by fellow employers, right? And based on observations, maybe even based on a blood alcohol, a breathalyzer or a blood alcohol test, you have empirical evidence there to determine whether or not they were impaired while they're at work. And that makes your job easier. And you may not have that easy on the marijuana side, but you should still be concerned about that licensee who's complaining about that other licensee about being impaired at work while they're high under the influence of a cannabis product, right? It might be a little bit harder for you to prove, but it doesn't negate you of your mandate and having to pursue it. So, any other questions before we, Kay?
Yeah, sorry. Thanks. Hey, Kate Tasso, thank you. Glad somebody knows who I am. Can you address a little bit then, so we know with alcohol and testing for alcohol impairment, what are the nuances with marijuana in terms of testing for that when somebody's under suspicion, and how long that lasts from when they ingest, and all the implications in terms of the board from there?
So alcohol is a much more empirically proven test, right? It's absolute, regardless of your sex or your body weight. We have all agreed that all of us can be impaired from alcohol below even standards that you see across the nation at like 0.08. But at 0.08, we know scientifically speaking that the human body cannot react at the same point that it could at a lower rate. So that's the point of impairment for alcohol, and it's pretty consistent across the United States. Some states are a little bit higher, some states are a little bit lower, but 0.08 is about the average. Marijuana is a little bit different because you can test for the presence of marijuana and metabolites of cannabis use, but there's no way for us to determine level of impairment like you can with alcohol, or even when the marijuana was consumed. There's some guesses towards when the marijuana was consumed, but it doesn't have that same empirical timeline that you have for alcohol. We know how quickly the body digests and metabolizes alcohol. All of you are different, and more importantly, especially in California, by the way, California has the best cannabis on the planet. It's weird for me to say that, right? All the cannabis is different, right? The cannabis today is not your mother and father's cannabis from yesteryear, right? This is not Haight-Ashbury. This is a whole different, industry. And so the concentrations of THC, while we defined at 3%, you're now seeing thresholds of 30 and 40% THC content in marijuana. So that's very hard to determine, and I think even more so very hard for your licensees to determine what proper use is for them, because there's an inconsistency in the quality of product that they may be using from day to day even. So on the investigative side, you really have to kind of rely back to observations, of that person's intoxication. What was the testimony of the licensees, right? You will have that evidence that says, yes, if you test them, there were metabolites. It shows that they had at least, partook in the use of cannabis, but you're not as tied down to when it happened or to what concentration it was done, and it won't really give you an idea of how impaired they were. You'll really have to rely more on the evidence, the other parts of evidence that you might have from testimony.
Jason, may I just step in real quick
Yes,
with that? So from a clinical perspective, when speaking to different providers that are responsible for doing a lot of the screening, let's say for a marijuana use disorder, they will oftentimes do these tests. The challenge with it, as we were just speaking to, is that these metabolites can be in a system for as long as 6 weeks after use, which is a very, very long time, and it may not necessarily be attributed to any kind of impairment at that point in time. So a lot of the questions that are clinically asked are associated with really two things. One, how often do you use cannabis? And two, how does it, have you experienced impairment associated with the use of cannabis? And if so, how often? And so a lot of the screening mechanisms that are used clinically are directly associated with these questions instead of some sort of objective test and measures that we typically associated with, let's say, testing alcohol levels in blood.
Just to add to that, for chronic use of marijuana, you can build baselines on a single use case, right? You can determine with a single person participating in a program what their metabolites look like over time based on the amount and frequency of their marijuana use. But without that, as something to compare to, you just don't have much at all.
This is more of a statement or thinking out loud with my limited experience with impaired practitioners. So I'm thinking that most employers are going to have a policy in place like they would with alcohol. You can't consume so many hours prior to. So let's just say someone shows up to work and they've, consumed 30 donuts in 10 minutes and they've got red eyes and what have you. Coworker tells HR, and they admit to it, or they say, yeah, I consumed marijuana, whatever, last night or 3 days ago, and it violates that policy. Then they get fired, and then there's a complaint filed and what have you. So I'm trying to think this through. I'm thinking the issue is more they violated the company policy, then got fired. I don't know that it's so much as an impairment. In Alabama, what would happen in that case is we would refer that person to our impaired practitioner program manager. He would then send that person for an evaluation and determine the degree of impairment. So they're going to probably have a complaint on file for sure, but they may could enter the wellness program
depending on the degree of impairment, there might not be a whole lot to it. Might have to go to a couple of classes, do some monitoring and what have you. But again, I'm just thinking out loud that it would be similar to alcohol consumption. And I understand fully that the measurement's totally different. But I don't know. I mean, I'm thinking, do most companies have a policy in place? I would think so.
Sure.
So that's
But-
just my thought.
And in your thought process, where you had said that, you would send them to that program, and in that program, there'd be an evaluation, and they would be asked those very same questions as part of that evaluation to help determine whether or not there was an issue with cannabis use. But you can take that same kind of scenario and just change it to alcohol, right? And just say, remove any kind of indicator of a breathalyzer or a BAC, and you find yourself in the very same situation, right? You have to determine whether or not that person was impaired. And there are other signs of impairment when it comes to their physical presence and how they demonstrate that you can use evidentiary, but it's not as nice as it is to have something like a BAC or a breathalyzer, or even for that matter, a conviction, right? So law enforcement involved, where they've done a lot of the homework for you a little bit, and that case comes to you that way. Aside from that, you could also live in a state like California where a governor signs a law that says the employer can't terminate them for use of cannabis because it has been recently legalized recreationally.
So, Jason, I just got my name mentioned here. Thank you. It is Nancy Kirsch from New Jersey. Thanks, Rich. Kapow to you as well. So backing it up a little bit, we tell people you have a duty to report, you see somebody that's impaired, you know that somebody is not working at the level that they should be. And then we get the pushback from our licensees saying, I'm not capable of making that kind of an assessment. How do I have the skill set to make an assessment on whether somebody's impaired? So just your thoughts on, or anybody's thoughts on, how do we as regulators help our licensees kind of either acquire the skills or feel more confident in their skills yeah, that person's impaired.
Yeah. So there's two things that I would say to that is that we've been saying see something, say something for a very long time. And at least in the day-to-day work that I do, my licensees have that down pat when it comes to alcohol, right? And so they kind of know what an impaired person under the influence of alcohol looks like. And they're more than eager to share those complaints with the board, right? I would just ask them to take those same observation skills and apply them to what they also know commonly as somebody who's impaired by the use of cannabis. Again, it's going to be hard for us to demonstrate that the impairment is actually happening at the time of work without that, right? Without that testimony, without that observation of the complainant saying, here's what I saw and how I saw it.
Jason, I'm just curious as to what rules or regs that your board put in place as it relates to legalized marijuana and those cases that come before you. Were there any changes there?
No, right? Because if it fits in the box, it fits in the box, right? So we were still looking at under the influence of a mind-altering substance. And so even though cannabis changed in its legal definition from, and one of the things that we would talk about in the definitions is like the legalization. I think legalization is kind of a misnomer. It's more of the additional regulatory control, right? It's a more regulated product now, but it's regulated for both medicinal and recreational use. It's still, as an example, in California, you can't carry over a certain amount of marijuana on your persons at any one time. You can't sell it, you can't distribute it, those kind of things. Those laws are still in effect. It's more about personal use. And so some of those are added layers of complication that you might run into in cases where it's not just under the influence or impaired. It's also, they were found to have marijuana on their persons while they were at work. They did openly admit to it or something like that. All of those things are things that you'll have to take into consideration.
I hope I can formulate this question correctly, but I don't really understand if I own a business and my employee comes to work impaired because they've had too much sleeping medicine or they've had too much hay fever, antihistamine, whatever they came to work that's a legal substance, cannabis is legal. If anybody comes to work impaired, I need to report that, whether it be cannabis or antihistamine or whatever, alcohol.
I would agree with that.
Yeah, that's what I'm thinking too.
Yeah, I would certainly agree with that because if you've ever had issues with your licensees and addiction, you know that when you limit their ability to take certain medications, they will sometimes find other ways of, unregulated substances, right? To an example I could think of is like whippets, right? The ingestion of nitrogen and CO2 just to get that lightheaded buzz, kill every brain cell in their brain, but just to get that lightheaded buzz. But it's not testable, right? They're smart, they want a high, and they're gonna find a way to get high. So whether it be cough medicine or anything like that, if they came to work impaired, it's certainly something that we would wanna be alerted to as a regulatory board.
Dave Relling, North Dakota. Jason, just wondering if you've had any communication with your educational programs and if that communication also includes how educational programs might communicate if a student was in a clinical education under impairment from marijuana or other substance, I guess, at this point.
So in California, we do a lot of outreach to cohorts as they're approaching graduation, and some have already gone through clinicals and some haven't. But I will tell you that in those class settings, the students are some of the people that make me shake my head and say that's not my favorite topic, right? I mean, they have some questions that we'll touch on in two other topics in this presentation, but I would say the school has much more jurisdiction in that situation to determine whether or not that person continues in the program at that point. And I think it's certainly something that they should consider. I can't imagine a subset kind of circumstances where that might come to the board's attention in the application process, but it would be, I don't think it would be something that would necessarily prove to be a barrier to licensure for them. We might want to put some kind of control in place to make sure that nothing happens post-licensure for a period of time until such time as we're more assured that they're competent and trustworthy and safe to practice.
Rugi Gonzalez, Oregon, very quickly. In your opinion and experience, what are your thoughts about developing a standardized, preferably a passive, observational test that we could document either as regulators, other licensees reporting, duty to report, or employers, right? Is there a way to establish like the field sobriety test that law enforcement does for alcohol, for example? And I won't get into consent, right? But is there any way, is it feasible to develop a standardized test, not only in the domain of marijuana use, but that drug classifications where you're impaired, visibly impaired? Do you see that in your view and experience as being possible and worth pursuing? Thank you.
So currently in law enforcement, you will find that they use the same FSTs for alcohol as they do for marijuana, or field sobriety tests, I'm sorry. I wouldn't recommend that for employers. I think you kind of get into a dicey legal ground in that area as to whether or not it will be legally binding, whether that becomes something in the future. In 1996, I didn't think we'd be where we are today when it comes to cannabis. So there's no telling where we might be in the future. And technology is changing all the time. We weren't able to test alcohol, 30 years ago the way we test it today either. And so I think that we'll see advancements in that as well.
Very interesting discussion. I very much appreciate your participating. Come back. Moving right along. But no, I do appreciate your comments, your thoughts. It gives us all a lot to be thinking about so far. If we have any knowledge on the topic, if we have researched it at all, we most certainly will share it with you. But everything that you're bringing up, I'm sure we're all thinking about things and we'll have questions most all the day. At this time, I want to move ahead to our second topic, which is past convictions of applicants, okay? From time to time, we will be getting, we get a exception roster when we do our Tuesday discipline calls, trying to keep up with all the things that have been turned in. A person may come through and they, got a hit on their PDA questions, and it states, well, I have a past possession of marijuana conviction. Do we issue the license? Do we not? Well, in Washington State, which is probably all I can really speak to, we do issue. And it goes back to, and my Washington compadres can assist me if I'm missing anything, to an interesting decision that occurred a few years back on a lady named Blake, Shannon Blake, I believe her name was, and she got caught with a bit of methamphetamine, I believe, in a jeans pocket, in a little side pocket. She stated she had no idea how it got there. It went to court and on and on. It ended up at the Washington State Supreme Court, where they deemed that the current drug possession law is unconstitutional. So essentially, not only decriminalize marijuana, but most all drugs. And so that kind of presented a quandary, right? Since then, there has been, I believe, Allison, a Blake fix put into place whereby it recriminalized many of these harder drugs, but made it a misdemeanor, not a felony. So every state is going to be a bit different when they present, here's this person moving in trying to apply for licensure in your state, and how are you going to manage that? So there may be also, it may be multifocal, right? It might involve several different substances. There might be different things going on with your applicants. And then these are just things I want to open this part of the discussion. What would be that impact on the good moral character type questions? Okay, so in Washington, recreational use is legal. So if I were to, I don't know, step out with Jeff for a quick bong hit before dinner, or whatever they do, but I'm probably using grandma language, aren't I? Do I have, but I'm at an FSBPT meeting and I just gave a presentation. I'm trying to do my part for the profession. Am I of good moral character? See, you have to think about it. It makes you take pause. So with those three items up there that I want you to be reflecting on, let's hear some feedback. Let's hear some questions, and if we know, we'll give you our answers, and if we don't know, well, it's something to think about.
I was going to kind of ask this earlier, but it kind of relates to all of it. What is this doing to employer-based drug testing for pre-screening for employment? And what are you seeing in your state?
Right.
And any implications thereof?
I think that by virtue of it being legal in our state, I don't think there's many screenings for THC or for marijuana use in our state. Now, if I were to go to work for the VA, well, that's a whole different deal, right? Because that's a federal entity. And Jason, what are they doing down south?
So I think employment is a whole different topic when you think about it, right? So this time last year, if an employer gave a pre-screening to an applicant and that applicant failed that pre-screening and the employer chose a pass, perfectly legal. Until recently, if that pre-screening only revealed marijuana, now there are protections in place for that applicant that can't be the sole denial for them for employment, at least in California, right? Anything other than marijuana, any other banned or controlled substance, and then it's a whole different topic.
Maybe Michelle might know better, but I believe that if you work in a facility that bills Medicare and you test positive, that could be an employment issue as well. because it's a federal.
Yeah, that's correct. And the other consideration is even if an Oregon-based employer wouldn't have those screenings, the reality of the profession, of course, is that sometimes the headquarters is in another state, and they set corporate policies or for travelers that are coming in. So it really is multifaceted.
Nancy Kirsch. So what happens when there's the law says you can't have a felony conviction and get a license, and the state has said that we no longer consider these felonies, but they have a felony conviction in another state, and that state doesn't eradicate it. And it's kind of like you're caught between the rock, the hard place, and the deep blue sea on what to do.
Well, that brings up a very, very good point, Nancy, in that until we have federal laws in place dealing once and for all with the criminalization or decriminalization of marijuana, it's going to probably be a state-by-state thing. And in Washington, it may be a felony in the state that the person's coming from, but if they're applying for a license in Washington and they had this prior marijuana conviction that was a felony in that state, I believe we would issue.
I would just add to that, for all of us in the room, more than just state by state, have to be case by case, right? Each case have to be looked at on its merits, because while that was a felony that may not necessarily be illegal in your state currently, was it at the time? And what was the gravity or the egregiousness of that felony conviction? Because if we're talking a felony conviction for possession for sale, that's a whole different matter. If it's a large quantity, that's a whole different matter. If there's more than one substance, that's exponential, and it just adds to the formula, right? So I think you really have to look at that on a case-by-case basis. And having said that, and checking my own biases, is that if it is just cannabis, and it would have been an acceptable level of quantity or even impairment at the time in California, I can't keep them out, right? That the law has changed, and I am just the sheriff of the PT Practice Act, so I don't have the law to keep them out. Come on in, but I'm watching you.
Katie, I'm going to go real quick.
Excellent question.
Katie.
Anybody else?
Katie.
Oh, sorry.
Hi.
Hi, Jeff.
Hi. I just want to kind of build up what Jason was speaking to right now, and this is really, yeah, exactly, we'll the bomb, yeah, we'll get that later. Yeah. Really speaking to the multifocal component associated with this, and what we've seen, at least from our experience, is that in a person-by-person case, you may see a possession associated with distribution. You may see maybe possession of one drug. I mean, marijuana itself, cannabis, is considered a Class B drug, psychoactive agent. It could be associated with another type of drug, maybe a Class A or Class C. Driving under the influence may be something else you may see as well. And again, depending on who the person is, that information would be assessed and reviewed on a case-by-case basis. So, thank you.
All right. Good points. Good points.
This is Charlotte Martin from Louisiana. I appreciate the question, Nancy, because I was thinking in my head how we would deal with that right before you asked the question. Would we look at if that's substantially equivalent or not? So I have a question. Do y'all have a matrix for deciding that you use in terms of, like, you have a new applicant and you look at, okay, it's been within the last 5 years, within the last 10 years, and different, not only related to this, but other things as well, to make decisions on applications?
Yes, that's good. That's a good question, and I hope that every state does do this. We got together as our board a year or so ago, Allison, I think it was a year or two ago, and we went through everything, but everything, not simply marijuana or substance abuse, but everything from I don't know, assault to urinating in public. I mean, you name it, it was there. And we went through and we built an exception matrix from that. And every year we review that. And we sort of put it on par with the other healthcare professions in our state to make it somewhat equivalent? Good question. Thank you. And get going on those matrices, you guys. It saves you a lot of hassle.
While we might not have a matrix, we do have a guidelines for issuing citations and imposing discipline that is this very thick book that all of my licensees can go to reference, if I violate this particular statute or this particular regulation, what is the potential outcome? And some of it can be very specific. Most of it ranges from you could get a citation or you can get your license revoked, right? I mean, because it comes down to this kind of case-by-case basis. Having said that, I've heard, in a couple presentations this weekend, we talked about things like precedent and avoiding the word precedent, but there is a concept in law called stare decisis, and it should be even-handed justice, right? So for similar circumstances, should have similar outcomes. But each case is case by case on its own merits. So you can have slight variables from one case, and with the matrix, I think the composition of the board changes. I think culture changes over time. I think new laws pass, and things that were, felony convictions 10 years ago are now, you can buy at the 7-Eleven in California. So, I mean, a lot changes in those situations.
I just wanted to mention that in Oregon, we haven't had any cases related to marijuana. Just a lot of questions more from employers or employees if they test positive, which is not a board issue. Like I said earlier, it's an employment issue.
Can I ask one follow-up question to that as well?
Yes.
Okay. Okay. So, if those matrices are publicly available or subject to open meetings law, can we request them to look at them? Maybe.
Oh, sure. You betcha.
And then,
my Minnesota came out, didn't it? Oh, you betcha. We'll send it right on down for you.
And then have y'all had any experience with, because I'm thinking past convictions of applicants means that you're just applying for a license, right? Because you're just finding out the information. Have y'all implemented background checks on individuals at renewal later, where now they may have had a past conviction, but they've already been in the nest?
No.
And so now you're having to deal with that?
No. We don't do background checks after it's issued. Is that your question?
No, let's say you didn't do background checks historically, and so now you're part of the compact, let's say, and you're starting to do background checks. So you go back and do background checks on all your licensees. And
You mean go
find
retro and do all that? No, I don't believe we do.
They're required to sign an affidavit upon renewal that there haven't been any additional new activities for
Jason, you have something to say?
The criminal-based background check in California is also a subsequent arrest subscription. So if I have an applicant who did not have criminal history, fingerprints with the board, and stays in California, practices, gets in trouble a year and a half down the road on a Friday night, I'm going to know Monday morning. So we'll have that information from law enforcement within about 48 to 72 hours.
My question is more about people who didn't have a criminal background check at the time they were licensed. And now, did your board decide, like, okay, we're going to do criminal background checks on new applicants, but also all the individuals who were already licensed? Have y'all done that?
See, I can't speak to that because all of my people
We do
are
criminal background checks when somebody applies for a license in Washington initially. As far as the compact people, I don't know. I think they because we are not the home state. Hold on, if you want to hold your questions for a second, I want to make sure that we hit all the topics we want to discuss today, and then we're going to leave a little 10 to 15 minute section at the end, then we can double back and try to scoop up all those things that we hadn't answered in times before, okay? So if you could just all bear with me a moment. I'm going to turn it over at this point to Jeff, who has just come back from, no, I'm kidding. Wait a minute, from stepping out. No. There you go. Okay.
All right,
sorry
thank you
about
very
this.
much.
Let me put this back for you. Oh, dear me and technology. Have fun.
Thank you. So, just from hearing some of the questions, one of the, I think direct questions actually was associated with how do we prepare our practitioners for these changes that are happening from jurisdiction to jurisdiction with regards to cannabis. And you know, the overarching, I think, idea or concept that our clinicians need to understand is that the prescription of cannabis falls well outside of our scope of practice, period. What it really comes down to then for our clinicians, our licensees, is whether or not they understand what we can say or cannot say. And when, again, with regards to cannabis, what we really can do is we can educate, right, our patients on the benefits and potential side effects associated with cannabis. Outside of that, nothing, right? And this ties in really to a few different things. One, how do we educate our current license holders? How do we educate our new licensees, let's say students graduating from school, or those that are maybe coming in from other state through compact, or maybe applying to another to Washington, in my case, from another state. You know, I work Tufts University. I'm a faculty, and so one of the questions that we constantly have is how do we update our current curriculum associated with the changes that are happening legally from jurisdiction to jurisdiction, and one of them being cannabis. We have information oftentimes in our differential diagnostic curricula associated with alcohol, for example. Now what you're seeing too is the inclusion of cannabis and associated signs and symptoms tied to cannabis use disorders. Some of the resources that clinicians are currently using, and just a little background with this, I'm all for not recreating the wheel. So what are other clinicians, what are other groups doing in order to educate their licensees? And yes, it's part of their graduate school training or undergraduate or certification, depending on who you're talking to. But I've had the opportunity to work with naturopaths, internal medicine physicians, acupuncturists, functional medicine, I mean, you name it. I've had interactions and worked closely with many of these different providers. And many of them all refer to a resource called Up to Date. I'm not sure if you are familiar with that. If not, it's a wonderful resource. And on it, it has a list of different screening techniques, tools, as well as signs and symptoms associated with the side effects with cannabis, and potentially when it becomes a concerning factor with specific regards to impairment. And with impairment, it really looks at that lifestyle component. Has their lifestyle changed to a certain extent enough where we are concerned about the side effects with cannabis? And again, that could be associated with work, it can be associated with sleeping, it could be associated with eating, weight gain or weight loss. Oftentimes when you see a clinical presentation, what a clinician is going to be identifying from a physical therapist standpoint are things like altered thinking, cognition, things like even in acute cases, ataxia, slurred speech, as well as an upset stomach or digestive issues. Some of the other things that may come up with conversations with our licensees, or you may see, is what about topical solutions that don't necessarily have THC but maybe CBD? What do we tell our clinicians associated with it? Can you use a topical ointment in addition to myofascial treatments? So they may come in with a script or some sort of indication from a provider that said, yes, use this ointment or lotion with a CBD element, and can they do that or not, right? And as long as that, if that prescription is coming from another provider, at least in Washington State, that provider can use that ointment or lotion as part of their myofascial treatment. As always, over-the-counter products and with regards to, let's say, pain management. And again, cannabis is a type B drug, and so we cannot advise with the use of cannabis. However, we can talk about benefits and side effects. Some of the misinformation about cannabis that I've experienced clinically, but also, and again, in my role as a regulator, really actually comes down to one thing, and whether or not cannabis is considered a supplement. It is not a dietary supplement. It is not. It is a psychotropic drug, and as such should be treated as such by our clinicians. And so that is something else that as you start to think as a board of how to go about educating your licensees, this is something that needs to be brought up continuously, right? Yes, it's used recreationally, but oftentimes, and I think what I've seen from the polling earlier is that more often it's legalized for medical use, right? This is a drug that's being used in order to manage chronic pain, anxiety, depression, and in some cases, let's say in oncological care, it can be used to actually help with weight gain, right? So I'm gonna stop talking because I will continue to talk. But I wanted to give you all an opportunity to ask me questions or the panel about some of these bullets up here that you can see.
I had a previous question, and then I'm going to have a follow-up after your statement. In reference to Charlotte's positions, I'm O'Day Laverne from Louisiana. Currently, our Practice Act, we require initial applicants to do fingerprinting for background check. We're in the process of redoing our Practice Act and are going to implement background checks on license renewals, so then everyone will have a background check. And then our question is, what's going to happen when we find out that they didn't report it, or that there was a felony, or there was something else? And then, you know, it's the social injustice issue. The little white kid on cocaine gets brought home to their parents, and the little brown kid with a half a joint gets put in jail for 20 years in Louisiana.
Yeah.
So just to say, oh, they had a felony conviction, to what extent? You know, were they bringing it in on a boat from Cuba? That's one thing. You know, did they have a half a joint at the Mardi Gras parade and get busted in New Orleans? You know, we have to have that freedom and that liberty to have some flexibility there. Okay. Secondly, to your point that it's outside of our scope, I would challenge that. Is that every day in my practice, we see a large population of military personnel, and these guys come back from deployment. They all have PTSD. Now, when they're still active military, they can't take any substance. But as soon as they're discharged, we then refer them to a physician to assist them with their PTSD. That's the number one benefit. They don't sleep. Just recently, retired general of the Louisiana National Guard comes to see me. I said, hey, most of your officers, the first thing they do when they get out, they want to smoke a joint. I said, have you had any pot? No. He said, I really hadn't. He said, not in 40 years. I said, well, how you sleeping? And his wife was my patient, and she said he hadn't slept in 30 years. So Thursday he sees the physician, and on Monday he comes back in and says, my God, I slept 8 hours for the last 3 days, every night. So I do think that it is in our scope of practice to be able to see anxiety, depression, chronic pain, lack of sleep, and then make that referral to the appropriate healthcare provider. So I'll caution you in how you say it's outside of our scope.
Yes.
We may not make the recommendation because physical therapists can't make that recommendation, but we surely can make the referral to the appropriate healthcare
Yes.
provider.
Yes. Well, no, thank you very much for that. And for your first point, I mean, it really speaks to the, you know, jurisdiction by jurisdiction, case by case analysis on how this is going to impact our patients, ultimately safety for the public, but also our individual licensees. Absolutely. Thank you for that, for your own experience with that. And you're right, absolutely. And I apologize if I was misinterpreted when I speak to the scope of practice. What I was really referring to is the direct prescription of and use of cannabis. I think referral to a provider and then acknowledging you will need to speak to that provider about the use of this particular substance, I've seen maybe benefit in other patients is something that, again, would fall within our recommendation, but ultimately would be decided by whatever provider does prescribe that particular substance. So thank you very much for that clarification. Yes?
Kate Tasso, Florida. So one of the things that we've seen in this state, and you guys know this state's a little different, is PTs selling CBD products. And so in that regard, recommending them and offering what appears to be misinformation, saying that you won't test positive if you have a drug screen, and yet we had some speakers, I think they were from Canada, that said, oh yeah, you will. So I don't know if you guys have any experience with CBD as supplements or whatever, and PTs recommending those, or in this case, even selling them.
I personally don't have, so I work in an alternative medicine clinic. I work jointly with naturopaths, as well as massage therapists and functional medicine providers. I have, all of the CBD lotions and different products that are generally applied topically, I do not have the ability to sell those items. And so I don't have any experience from that standpoint. Do you three have any experience with that? Jason, you're nodding your head. Yeah.
To Jeff's point earlier, cannabis is not a nutritional supplement, right? In California, we don't have licensed nutritionists. Everyone in healthcare can provide nutritional advice. They fall under the Medical Practice Act when they do that, and there's disclaimers for that. And we've seen that CBD products tend to fall in those categories as long as the THC values are beyond a certain or below a certain threshold. The caution I would give to that, and I think to your point with the Canadian advice, was that the quality control on those products is not the best, and whatever you see on the label, you don't trust it because it might cause you problems in the future. No one ever asked me this question, like every day, right? I mean, it's been sold to me as a business advantage. Other healthcare practitioners are selling this in their practices, and I'm missing out on an opportunity for revenue if I don't do it. And what I would caution to my licensees is, yes, you can do it, and you can get in trouble for it. So just, take that as a word of caution.
Just to reiterate what Jeff said, in our state anyway, you can educate your patients on cannabis, marijuana. You can educate them on anything, but you can't prescribe, you can't advise, but you can educate.
So when looking at some of the questions about, what our licensees may, do we have a question?
Well, Ellen Donald, Florida. I just want to tag on to that. There were, at an FPTA educational session, there was someone that was advising the group on how to expand your business and offer these products or use them, lotions, oils, in combination with the other therapeutic interventions, sell it in your front office, that kind of thing. And what the woman very clearly made very clear, even though she sells, she applies, she does all that in this state, she said, made it very clear, if you don't know your product source, you're liable. And the issue, I like that you have risk and liability. This situation came up of a truck driver applied these lotions through their therapeutic interventions to a person who drives on our highways and roadways, and the person basically lost their license because that patient tested positive for THC, because in these CBD products, they're not as regulated as you would think, and depending on what the source is, there's THC in it. You think a police officer, you think anyone, if your patient is someone who is in a profession that could have their livelihood taken away, who are they going to come back to when they want to sue someone? So I think the issue, sometimes the aha in the audience was, oh wait, and that was more the aha than anything else, is like, oh wait, I could have a big lawsuit against me for doing that, and that was kind of a good aha.
The only words of wisdom that I would add to that, and I don't have many words of wisdom to add, is, and this is just like a food for thought kind of concept, physical therapy has always has been explained to me as being a very evidence-based art and science, right? And this is one opportunity where we might wait until there's some evidence-based material before we start getting so excited about using it, because essentially, to Alan's point, the liability will fall back to you as the practitioner. So.
Yeah, no, just to reiterate, these things are not pure. Because they're federally illegal, The FDA does not regulate their production. In fact, it's almost a truism that the people who advocate their use will say that they're pure CBD or whatever nonsense. The truth is the very same people will be the first people to say that things that are pharmaceutically produced, like vaccines, are putting poison in your body, and those things are actually regulated and standardized. So we have this double standard.
So, yeah, thank you. And I think that's, interestingly enough, that's one of the, in talking to different boards in Washington as well as different providers. Now, understand this has not have been validated. I didn't do any statistical analysis on this. But there are 5 themes that came out of my conversations with other clinicians and other boards regarding what they really have questions about with the use and regulation of cannabis, not only for boards but also for their practitioners. And the 5 are the regulation of authorized prescribers of cannabis, the education regarding the benefits and risk of cannabis, which include finding the balance between lifestyle, medical management, and cannabis use, the threshold for therapeutic effect, the concern regarding the lack of standardization of dosage and formulations of THC, and the presence in other products such as CBD, the identification of cannabis misuse, and of course, and as well as disclosure of cannabis use and stigmas associated with cannabis use. So those, again, are really the 5 topics I found to be most pressing for many of the different clinicians and boards that I did speak to. And I think it really, again, is associated with some of the conversations we're having right now. And just to reiterate, there is no regulation really at all on the formulation of THC and what's present in what kind of substance that is made from cannabis-derived products. So I really appreciate all the questions. We're going to go ahead and move to our next slide. And I know that we have already discussed a lot of your questions, but if there are any more, please share them with us. And if we're not able to get to them today because we are running short on time, please come and find us, and we'd love to have a conversation with you about it.
All right. So, yep, okay, so yeah, I guess you're supposed to join us at Slido. Anyway, but I do want to thank each and every one of you. This is a really interesting breakout session. I wasn't sure how it was going to go because everything is so new. And your participation and your candidness and questions and comments have really brought a lot more to light, at least for me. And I hope they have for you. As you go back to your respective jurisdictions, and this will come up, hopefully you're armed with a little more knowledge and a little more wisdom as to what other states are doing and what path you all intend to head down. The only other thing I might add to that is just stay on top of any legislation, even in your neighboring states, because it is moving through the country, and we're going to have to move with it, whether or not we want to, if we want to be decent regulators, right? We have time for maybe one more question, actually, if anyone has any final parting thoughts.
What about possession of products by the PT during work hours, whether it be a topic or just their personal
In
possession?
Washington State, anyhow, I can only speak for that. If it's on their person and they're not impaired, what's that?
I think there's a certain amount.
Oh, yeah, you can't have 10 pounds sitting in your backpack, you know. Just a little something, no. But if a small amounts, there really is, it's like having one of those little, airplane bottles, I guess, of liquor or something? Yeah. I don't know. I mean, I know it's not chargeable, but I do know that, I don't know what the equivalencies are.
Typically, the guideline is anything less than an ounce, right? Anything over an ounce. And in California, the actual statute says an ounce and 4 grams, because we all know that when they're weighing it out, right, that it's going to be a fat ounce. right? And so even the law took into account their inability to weigh marijuana on a scale.
Because after all, they are impaired, right? No, I'm just kidding. But it will depend state by state. And I believe, thank you for mentioning that, Jason, because I think in Washington it is similar up to an ounce. I think it's 8 ounces. Oh my word. Charlotte, I'm moving to Louisiana.
That's a
What's that?
That's a lot of personal use.
Yeah. Yeah. Okay. I think we're about out of time. Thank you again, everybody, as we journey through this.